You're watching Bill on Bankruptcy. I'm Lee Pacchia. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal, and it is fantastic. Bill, welcome.
Good day.
Wow, we're starting off with ResCap, and Bill, my jaw just dropped when I read your column and found out that it will cost $83 million to complete the examiner's report for the ResCap bankruptcy case. That, of course, is the mortgage servicing subsidiary of Ally Financial. I don't have a table of how much examiner investigations usually cost, but this strikes me as ridiculously high. Is it ridiculously high, and why is it?
Well, I tell you what, it depends on how you look at it. Per page, it's not so expensive. It's about $10 a page. Well, however, that's spread across 9 million pages of documents that the examiner brought in from all kinds of third parties.
So was it ultimately worth it?
That is going to be told to us by whether or not there is a settlement. These days, it's turning out that examiners are really being used to lay out the bloody facts, like it or not, so that recalcitrant folks decide to settle. If there is a quick settlement here, then believe me, $83 million was cheap at any price. That, of course, doesn't entirely depend upon the examiner. It really, in large part, depends upon third parties in terms of whether or not they see the bloody hand of the future in the examiner's report. We have seen some other cases where there were not examiners so quickly that ran on forever, probably costing multiples of what it would have cost had there been a quickly conceived and written examiner's report. Here, I can only say it's too bad that the report is not coming in sooner. The examiner was officially appointed back in August, and originally the report was to be in by February. And at the time, had it come in February, the cost would have been about half as much. But as I said, the examiner has been inundated with documents brought in from third parties. And by the way, the examiner here is none other than former bankruptcy judge Arthur Gonzalez, recently retired from the federal bankruptcy bench in New York. Judge Gonzalez very much deserves every dollar he is going to get out of this case. And as a matter of fact, by my rough calculation, he will be paid for his examiner's work about let's put it this way. His 9 months of work for examiner will compensate him about as much as 3 years of work as a bankruptcy judge.
It's a totally different world Judge Gonzalez finds himself in these days.
Nobody deserves it more than he. He served long and well.
Right on. And we're going to jump to an interesting item. For the casual reader, Bill, your column is something I'd call the antithesis of a tabloid. Yet you wrote a story on Casey Anthony, the woman who was acquitted of murdering her 2-year-old daughter about a year ago, I guess. How come we're talking about Casey Anthony today?
Well, that's because hard cases make bad law, and this is a really hard case. As you said, she was acquitted. There, by the way, in a trial that was virtually played out on daytime TV. After she was acquitted, she has been hounded in lawsuits by people who, I guess, thought it was a miscarriage of justice that she was not convicted for murdering her tiny daughter. She filed Chapter 7 bankruptcy eventually to stop those lawsuits, and then lo and behold, someone comes along to buy her life story from the trustee for $10,000, ostensibly to prevent her from doing a book or a movie deal sometime in the future. Now, this is all well and good, and I can understand the purpose to that, sort of like the Son of Sam law in New York. But on the other hand, is this bankruptcy law? Is there property here that the trustee owns? In other words, Lee, if I file bankruptcy tomorrow, am I precluded from telling a story about anything that happened in my life before the day I filed bankruptcy?
That's a really interesting question. How do you think that's going to turn out?
Well, my guess is that there will not be found to be a property interest here, except perhaps some very small sliver. But nonetheless, I'm not going to predict how this comes down, because this could go all the way to the Fifth Circuit, if not to the U.S. Court of Appeal, or to the Supreme Court. But I shouldn't say Fifth Circuit. It will go to the 11th Circuit in Atlanta, because this is a case in Florida.
And Bill, of course, these video discussions wouldn't be complete without some mention of Stern v. Marchal. That, of course, is the Supreme Court case holding that bankruptcy courts don't have constitutional power to make final decisions in some types of lawsuits. I understand that there's a follow-up case coming to the Supreme Court sometime soon. Tell us about it.
Yes, sir, Bob. It's called Executive Benefits Insurance versus Arkinson.
That's not as easy to say as Stern v. Marchal.
No.
I hope that doesn't become the most important Supreme Court decision in bankruptcy going forward.
The decision came down in December from the Ninth Circuit out in San Francisco. The question in the case was, can rights under Stern versus Marchal be waived? And the Ninth Circuit said, no, sirree, they can be waived. They can be waived. Interestingly, 2 months before that, the Court of Appeals in Cincinnati ruled that Stern rights cannot be waived. So, ergo, we have a stark split of circuits, and the Supreme Court is prone to taking cases where there are disagreements among the circuit courts. This is a hugely important decision, and my instinct tells me, Lee, that I don't think the Supreme Court is going to take this case just yet. Because I don't think the split of circuits is yet very fully fleshed out. The Ninth Circuit decision was very comprehensive. The Sixth Circuit decision wasn't so much so. However, I will make one prediction. That is, if the Supreme Court does take this case, I think that increases the odds that there will be a reversal, finding that Stern rights cannot be waived. And if they cannot be waived, that is simply, in my view, another nail in the bankruptcy court's coffin, saying that, frankly, bankruptcy courts are not really courts.
And as usual, we're going to conclude with our advantage sheet section. That's where we discuss important new opinions that are coming out in the bankruptcy courts. And Bill, it seems that your hero, Judge Richard Posner from the Seventh Circuit Court of Appeals in Chicago, owns this space. He has an absolute monopoly on the thing because we're talking about one of his opinions again this week. What's this one all about?
Well, you're right, because last week it was Judge Posner also. This is for bankruptcy wonks. If you're not, tune off. You don't care.
No, that's not true. Keep watching. We need the clicks.
The issue is as follows. In bankruptcy, a trustee, or a debtor for that matter, has 2 years in which to bring lawsuits under bankruptcy law. The law says that if a trustee is appointed before that 2 years runs out, there is an extension granted for 1 year. The question is, that Posner decided, if there is a conversion of a case to Chapter 7 before the period runs out, but the trustee is not finally appointed until after it runs out, do you get the additional 1 year or not? Judge Posner says you don't get it. He followed a similar decision from a few years ago called American Pad from the Third Circuit. But here we go, another beautifully written decision by Judge Posner. Oh, and by the way, I forgot, the way it was handed down was marvelous. This thing was never even argued in the circuit court. It was a bankruptcy court decision. They made an application for a direct appeal to the circuit court. The circuit court read the brief on whether or not they should take the case and just proceeded to decide the whole cotton-picking case right there based on the motion for an interlocutory appeal.
Right on. Good stuff. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go pick up his column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacchia. Thanks for watching.